Content of this module. Number 1. Meaning of pure obligation. 2. Meaning of conditional obligation. 3. Condition. 4. Distinctive between suspensive and resolutory condition. 5. Classification of condition. 6. Remedies. Introduction. Classification of obligations. Number 1. Primary classification of obligation under the Civil Code. A. Pure and conditional obligation. B. Obligation with a period. C. Alternative. D. Joint and solidary obligation. E. Divisible and indivisible obligations. F. Obligation with a penal cost. 2. Secondary classification of obligation under the Civil Code. A. Unilateral and bilateral obligation. B. Real and personal obligation. C. Determinate and generic obligation. D. Civil and natural obligation. E. Legal, conventional, and penal obligation. Lesson discussion, Article 1179. Every obligation whose performance does not depend upon a future or uncertain event or upon a past event unknown to the parties is demandable at once. Every obligation which contains a resolutory condition shall also be demandable without prejudice to the effects of the happening of the event. Meaning of pure obligation. A pure obligation is one which is not subject to any condition and no specific date is mentioned for its fulfillment and is therefore immediately demandable. Meaning of conditional obligation. A conditional obligation is one whose consequences are subject in one way or another to the fulfillment of a condition. Meaning of conditional. Condition is a future and uncertain event upon the happening of which the effective or extinguishment of an obligation subject to it depends. Characteristic of a condition. Number 1. Future and uncertain. In order to constitute an event as a condition, it is not enough that it be future. It must also be uncertain. The first paragraph of Article 1179 obviously uses the disjunctive or between future and uncertain to distinguish pure obligation from both the conditional obligation and one with a period, be that as it may, the world or should be end. Number 2. Past but unknown. A condition may refer to a past event unknown to the parties. If it refers to a future event, both its very occurrence and the time of such occurrence must be uncertain. Otherwise, it is not a condition. A condition must not be impossible. Two principal kinds of condition. Number 1. Suspensive condition. Condition precedent or condition antecedent, or one the fulfillment of which will give rise to an obligation. In other words, the demandability of the obligation is suspended until the happening of the uncertain event which constitutes the condition. Number 2, resolutory condition, or one of the fulfillment of which will extinguish an obligation already existing. Distinction between suspensive and resolutory conditions. The difference between the two conditions is very clear. Both bear an influence on the existence of the obligation, but in diametrically opposed manner. Number 1. If the suspensive condition is fulfilled, the obligation arises, while if it's the resolutory condition that is fulfilled, the obligation is extinguished. Number 2. If the first does not take place, the tie of the law does not appear, while if it does the other, the tie of law is consolidated. And number 3, until the first takes place, the existence of the obligation is a mere hope, while in the second its effects flow, but over it hovers the possibility of termination. When obligations is demandable at once. An obligation is demandable at once Number 1, when it is pure. Number 2, when it is subject to resolutory condition. And number 3, when it is subject to resolutory period. Past event unknown to the parties. A condition really refers only to an uncertain and future event. A past event cannot be said to be a condition since the demandability of an obligation subject to a condition depends upon whether the event will happen or will not happen. Article 1180. When the debtor binds himself to pay when his means permit him to do so, the obligation shall be deemed to be the one with a period, subject to provision of Article 1197. Where duration of period depends upon the will of debtor. A period is a future and certain event upon the arrival of which the obligation subject to it either arises or is extinguished. The debtor promises to pay when his means permit him to do so. The obligation shall be deemed to be one with a period. In this case, what depends upon the debtor's will is not whether he should pay or not, for indeed he binds himself to pay. What is left only to his will is the duration of the period. If the debtor and the creditor cannot agree as to the specific time for payment, the court shall fix the same on the application of either party. Number 2. Other cases, as when the debtor binds himself to pay. A. Little by little. B. As soon as possible. C. From time to time. D. At any time I have the money. E. In partial payments. F. When I am in position to pay. Article 1181. In conditional obligation, the acquisition of rights as well as the extinguishment of or loss of those already acquired shall depend upon the happening of the event which constitutes the condition. Effect of happening of condition. This article reiterates the distinction between a suspensive condition and a resolutory condition. Number 1. Acquisition of rights. In obligation subject to a suspensive condition, the acquisition of rights by the creditor depends upon the happening of the event which constitutes the condition. Number 2. Loss of rights already acquired. In obligation subject to a resolutory condition, the happening of the event which constitutes the condition produces the extinguishment or loss of rights already acquired. Article 1182. When the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void. If it depends upon a chance or upon the will of the third person, the obligation shall take effect in conformity with the provision of this code. Classification of condition. Conditions may be classified as follow. 1. As to effect. A. Suspensive, the happening of which gives rise to the obligation, and B. Resolutory, the happening of which extinguishes the obligation. 2. As to form. A. The condition is clearly stated. B. Implied. The condition is merely inferred. As to possibility. A. Possible. The condition is capable of fulfillment legally and physically, and B. Impossible. The condition is not capable of fulfillment legally or physically. 4. As to cause or origin. A. Potestative. The condition depends upon the will of one of the contracting parties. B. Casual. The condition depends upon chance or upon the will of a third person. And C. Mixed. The condition depends partly upon chance and partly upon the will of a third person. 5. As to mode. A. Positive. The condition consists in the performance of an act, and B. Negative. The condition consists in the omission of an act. 6. As to numbers. A. Conjunctive. There are several conditions and all must be fulfilled, and disjunctive. There are several conditions and only one or same of them must be fulfilled. 7. As to divisibility. A. Divisible. The condition is susceptible of partial and performance, and B. Indivisible. The condition is not susceptible of partial performance. Potestative condition, a condition suspensive in nature in which depends upon the sole will of one of the contracting parties, is known as potestative condition. For suspensive condition depends upon will of debtor. 1. Conditional obligation void. Where the potestative condition depends solely upon the will of the debtor, the conditional obligation shall be void because its validity and compliance is left to the will of debtor, and it cannot therefore be easily demanded. In order not to be liable, the debtor will not just fulfill the condition. There is no burden on the debtor, and consequently, no juridical tie is created. Number 2. Only the condition void if the obligation is a pre-existing one and therefore does not depend for its existence upon the fulfillment by the debtor of the potestative condition. Only the condition is void, leaving unaffected the obligation itself. Here the condition is imposed not on the birth of the obligation but on its fulfillment. Where suspensive condition depends upon will of creditor, if the condition depends exclusively upon the will of the creditor, the obligation is valid. Where resolutory condition depends upon will of debtor, if the condition is resolutory in nature, like the right to repurchase in a sale with pacto directo, the obligation is valid although its fulfillment depends upon the sole will of the debtor. The fulfillment of the condition merely causes the extinguishment or loss of rights already acquired. The debtor is naturally interested in its fulfillment. Casual condition. If the suspensive condition depends upon chance or upon the will of a third person, the obligation subject to it is valid. Mixed condition. The obligation is valid if the suspensive condition depends partly upon chance and partly upon the will of a third person. Article 1183. Impossible condition. Those contrary to good customs of or public policy and those prohibited by law shall annul the obligation which depends upon them. If the obligation is divisible, that part thereof which is not affected by the impossible or unlawful condition shall be valid. The condition not to do an impossible thing shall be considered as not having been agreed upon. Two kinds of impossible condition. There are physically impossible condition when they in nature of things cannot exist or cannot be done. 2. Legally impossible condition when they are contrary to law, morals, good customs, public order, or public policy. Effects of impossible conditions. Number 1. Conditional obligation void. Impossible conditions annul the obligation which depends upon them. Both the obligation and the condition are void. The reason behind the law is that the obligor knows his obligation cannot be fulfilled. He has no intention to comply with his obligation. 2. Conditional obligation valid if the condition in negative that is not to do an impossible thing, it is disregarded and the obligation is rendered pure and valid. Actually, the condition is always fulfilled when it is not to do an impossible thing, so that it is the same as if there were no condition. The obligations are pure and therefore demandable at once. 1. Only the affected obligation void. If the obligation is divisible, the part thereof not affected by the impossible condition shall be valid. 2. Only the condition void. If the obligation is a pre-existing obligation and therefore does not depend upon the fulfillment of the condition which is impossible for its existence, only the condition is void. Article 1184. The condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expires, or if it has become indubitable that the event will not take place. Positive conditions. The above article refers to positive condition. The happening of an event at a determinate time, the obligation is extinguished. 1. As soon as the time expires without the event taking place, or 2, as soon as it has become indubitable that the event will not take place although the time specified has not expired. Article 1185. The condition that some event will not happen at a determinate time shall render the obligation effective from the moment the time indicated has elapsed or it has become evident that the event cannot occur. If no time has been fixed, the condition shall be deemed fulfilled at such time as may have probably been contemplated, bearing in mind that nature of the obligation. Negative condition. The above provision speaks of a negative condition that an event will not happen at a determinate time. The obligation shall become effective and binding. Number 1, from the moment the time indicated has elapsed without the event taking place, or 2, from the moment it has become evident that the event cannot occur, although the time indicated has not yet elapsed. Article 1186. The condition shall be deemed fulfilled when the obligor voluntarily prevents its fulfillment. Constructive fulfillment of suspensive condition. There are 3 requisites for the application of this article. A. The condition is suspensive. B. The obligor actually prevents the fulfillment of the condition. And C. He acts voluntarily. The law does not require that the obligor acts with malice or fraud as long as his purpose is to prevent the fulfillment of the condition. He should not be allowed to profit from his own fault or bad faith. Constructive fulfillment of resolutory condition. Article 1186 applies also to an obligation subject to a resolutory condition with respect to the debtor who is bound to return what he has received upon the fulfillment of the condition. Article 1187. The effects of a conditional obligation to give once the condition has been fulfilled shall retroact to the day of the constitution of the obligation. Nevertheless, when the obligation imposes reciprocal prestations upon the parties, the fruits and the interest during the pendency of the condition shall be deemed to have been mutually compensated. If the obligation is unilateral, the debtor shall appropriate the fruits and interest received, unless from the nature and circumstances of the obligation it should be inferred that the intention of the person constituting the same was different. In obligation to do and not to do, the court shall determine in each case the retroactive effect of the condition that has been complied with. Number 1. In obligation to give. An obligation to give subject to a suspensive condition becomes demandable only upon the fulfillment of the condition. However, once the condition is fulfilled, its effects shall retroact to the day when the obligation was constituted. 2. In obligation to do or not to do, with respect to the retroactive effect of the fulfillment of a suspensive condition, in obligation to do or not to do, no fixed rules is provided. Retroactive effect as to fruits and interest in obligation to give. 1. In reciprocal obligations, there is no retroactive because the fruits and interest received during the pendency of the condition are deemed to have been mutually compensated. This rule is necessary for purposes of convenience since the parties would not have to render mutually accounting of what they have received. Fruits here may be natural, industrial, or civil fruits. Article 1188. The creditor may, before the fulfillment of the condition, bring the appropriate actions for the preservation of his rights. The debtor may recover what during the same time he has paid by mistake in case of a suspensive condition. Rights pending fulfillment of suspensive condition. 1. Rights of creditor. He may take or bring appropriate actions for the preservation of his rights, as the debtor may render nugatory the obligation upon the happening of the condition. Thus, he may go to court to prevent the alienation or concealment of the property the debtor has bound himself to deliver, or to have his right annotated on the title to the property in the registry of deeds. Number 2. Rights of debtor. He is entitled to recover what he has paid by mistake prior to the happening of the suspensive condition. This right is granted to the debtor because the creditor may or may not be able to fulfill the condition imposed, and hence it is not certain that the obligation will arise. This is a case of solution indemnity, which is based on the principle that no one shall enrich himself at the expense of another. Article 1189. When the conditions have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in case of the improvement, loss, or deterioration of the things during the pendency of the condition. 1. If the things is lost without the fault of the debtor, the obligation shall be extinguished. 2. If the thing is lost through the fault of the debtor, he shall be obliged to pay damage. It is understood that the thing is lost when it perishes, or goes out of commerce, or disappears in such a way that its existence is unknown or it cannot be recovered. 3. When the things that deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. Number 4. If it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment, with indemnity for damage in either case. 5. If the thing is improved by its nature or by time, the improvement shall inure to the benefit of creditor. 6. If it is improved at the expense of the debtor, he shall have no other right than the granted to the usufructuary. Requisites for application of Article 1189. Article 1189 applies only if 1. The obligation is a real obligation. 2. The object is specific or determinating. 3. The obligation is subject to a suspensive condition. 4. The condition is fulfilled. And the last one is 5. There is loss, deterioration, or improvement of the things during the pendency of the condition. Kinds of loss. Loss in civil law may be: Number 1. Physical loss, when a thing perishes, as when a house is burned and reduced to ashes. 2. Legal loss, when a thing goes out of commerce, like when it is expropriated, or when a thing heretofore legal becomes illegal. Or 3. Civil loss, when a thing disappears in such a way that its existence is unknown, or even if known, it cannot be recovered. Kinds of obligation according to the person obliged. They are: 1. Unilateral, when only one party is obliged to comply with the prestation. 2. Bilateral, when both parties are mutually bound to each other. In other words, both parties are debtors and creditors of each other. Bilateral obligation may be reciprocal or non-reciprocal.